So without further ado, I'm just going to launch into the slides and hopefully cover all the main points that you have pressing on your mind at the moment. Just having a few technical difficulties here, folks, trying to get to the second slide, so bear with me. It's always the way whenever you have technical. There we go. So as I said, my name is Ganesh, co-founder of Landed, and just to give you a bit of background as to who Landed are, we're a recruiting software company. We develop applicant tracking systems and candidate screening solutions for in-house recruitment teams. So basically we came into existence 4 years ago. We spent our first 2 years very much in development. And the reason we're probably slightly different to your traditional ATS company is that my background is recruitment, that of my business partner is of marketing and digital marketing, and we've combined those two nuances together to create a recruitment marketing platform that also incorporates applicant tracking. The reason we've become obviously experts in the area of GDPR is because it's a main focus for anybody that handles data, so we've spent quite a bit of time and resources gathering our information. I'm also going to cover in what GDPR is, how it differs to the Data Protection Act, what the accountability and governance concepts are, what consent you need to get, privacy notices, cookies, breach of reporting sanctions, and overall then I'll give a summary on how we can obviously help you as an organisation. So Landed, as I said, is a recruitment marketing software company, and we focus on transforming the way companies market their job opportunities and how they collect and screen applicant data, with our main aim being to enable them to make better hiring decisions. Our solutions gives the business the ability to create and publish and track and analyse all of your recruitment marketing campaigns, and our experience crosses online recruitment to provide on-hand expert advice to digital recruiting services. As I said, we were established 4 years ago in 2014 and spent our first few years in development. And we've worked really hard to develop software and technology that not only changes how HR and recruitment teams function, but also plays an important part in ensuring that you stay compliant to all of regulations. But today we're really here to talk about GDPR and what GDPR is and how it's going to impact you. So the General Data Protection Regulation, in its full terms, will come into effect in the UK from the 25th of May 2018. The DPA was a directive, whereas the GDPR is a regulation. So where that main difference is, the Data Protection Act was something that you would do with good practice, but GDPR is a regulation and all member states must implement it. GDPR applies to data controllers and processors, and the definitions are broadly the same as under the Data Protection Act. If you're currently subject to data protection, it is likely that you will also be subject to the GDPR. The regulation places specific legal obligations on data processors. For example, you are required to maintain records of personal data and processing activities, which is processing applications through from application through to job offer or rejection. You will also have significantly more legal liability if you're responsible for a breach. Data controllers will have additional responsibilities to ensure their process and contracts comply with GDPR. The regulation applies to personal data, which is any given data that can identify a living individual. It does not apply to business data, for example, to accountants, but it does apply to recruitment in that you are taking individual information in regards to people's names, dates of birth, and any other information about their previous employment. So the essence of legislation is to safeguard the rights of EU citizens, to put control back in the hands of the data subject, forcing businesses to take a proactive approach to data protection. The UK government that has confirmed that legislation will not be affected by the decision to leave the EU, and it has already been passed in EU law, and in May 2018 deadline is for implementation by all member states. So regardless of the outcome of Brexit, GDPR will take effect and will need to be applied this May. Applies to the process of personal data for EU citizens regardless of whether or not that is located in the EU or not. So if you have offices, for example, in the United States, but they are processing information from your potential applicants from any EU country or from your current organisations, then they must also comply with GDPR. So it applies to anybody handling information of an EU citizen, regardless of where they're located. So what is new with regards to GDPR and how it differs from the DPA? The two key areas of GDPR are accountability and data governance. Controllers and processors are required to implement the regulation and demonstrate that they do so. Demonstrate being the key point here. Businesses must put systems in place to ensure that they can prove compliance. This requires management buy-in, a top-down approach, and adequate processes to maintain and monitor compliance. The definition of personal data has remained largely the same, but has been expanded under GDPR to include data such as online identifiers, including IP addresses or cookies. These are now classed as personal data. Sensitive personal data classed as specialised categories of data include genetic data, biometric data, or data concerning health, and GDPR requires explicit consent for processing such data. Companies processing large volumes of special category data should also appoint a data protection officer. So that, for example, would apply if you are collecting a health monitoring forms or health questionnaires as part of your recruitment process. And if you're doing that in large volume, you must appoint a data protection officer. GDPR applies to both automated personal data and manual filing systems. So by all means, we're not saying that you have to rush out and buy an applicant tracking system or a recruitment system, although personally we would quite like you to do that. But it does apply to your manual filing systems. You can still ensure that they apply or comply with GDPR guidelines by making sure that your manual filing systems are fit for purpose, and that they're easily searchable, and that candidate records can be achieved and retrieved and destroyed if need be. So if your filing cabinet is full of candidate records and the employee personal files are covered under this regulation, and appropriate safeguards need to be put in place around that manual filing system to avoid any data breaches. So even if you are going to implement a new system now, you will have old data. That data needs to be protected under the new guidelines. Data subjects have additional rights under GDPR in respect to how their data is handled, and specifically the right to port their data and the right to be forgotten. For example, if I decide to move to a new dentist, I have the right for the data from my current dentist and my dental record files to be transferred to my new dentist without any undue delay. In the case of the recruitment process, if I no longer wish for a company to process my data, I have the right to request full deletion of my applicant record and associated data, subject to any restrictions in respect of governing laws, etc. Consent will be harder to obtain and harder to rely on, so companies need to put tracking mechanisms in place to ensure that they can both gather consent efficiently and maintain it. And I'll go further into this in a bit more detail on how to manage consent shortly. Special emphasis has been put on transparency. Companies need to update their privacy statements to be concise, clear, and unambiguous. They should be standardized and auditable. You should ensure that you keep log of changes to privacy statements and put processes in place that will track the policies that were in place when an individual provided their data to you. Profiling is specifically mentioned in GDPR, and any automated decisions must be notified to an individual. Data subjects have the right to request human intervention, and we will touch upon how this affects the recruitment marketing activities later on, and also how it can impact things such as automated filtering processes, which is now offered by a lot of applicant tracking systems. Penalties for breach of GDPR are extremely onerous and have the potential to cripple any small business. Fines of up to 20 million euros or 4% of global annual turnover can be imposed. The ICO is a regulatory body in the UK responsible for ensuring GDPR is adhered to. Data transfers to non-EU countries are specifically mentioned in GDPR, and the authorities have issued a white list of countries which are deemed to have adequate data protection. Important to note, the USA is not on this list, and the new EU-US Privacy Shield replaces Safe Harbor, and you should ensure that any US-based processors are self-certified under the Privacy Shield. Article 5 of the GDPR guidelines sets out principles in relation to processing personal data and legislates for concept of accountability. Processed lawfully, fairly and in a transparent manner. Collected for specific, explicit and legitimate purposes. Adequate, relevant and limited to what is necessary. Accurate and where necessary, kept up to date. Retained only for as long as necessary and processed in an appropriate manner to maintain security. This statement overall raises the bar across the board and will be key to demonstrating accountability. Privacy statements must provide more detailed information and be concise and easy to understand. Consent must be unambiguous. Profiling will be subject to greater focus and scrutiny. Mandatory breach of notifications introduced. And the bottom line is businesses need to shift focus on proactive approach to data protection rather than in previous generally reactive. Data governance is closely tied to accountability and organisations need to put good governance in place. Specifically required within GDPR are that all public bodies must appoint a data protection officer, as do organisations processing large amounts of sensitive personal data and organisations whose core activities is the systematic monitoring of data subjects. This has resulted in a shortage of DPOs, and as such you may wish to consider which staff within your organisation may be suitable for taking on the role and provide adequate training. I would highly recommend the GDPR practitioner qualification with IT governance. And this is something we have put one of our key members, Michael Green, who's prepared the slide through, and it is proving invaluable to us as a resource to answer any questions and guiding us in our implementation of GDPR policies. Process is key. Identifying and carrying out DPIAs and establishing data protection by design and default. Think about how you could meaningfully keep records and how to build up a single view of all interactions with a data subject. Where there is a high risk to data subjects' rights, GDPR requires mandatory DPIAs to be carried out. Consider whether current marketing activities and recruitment marketing activities are designed within data subjects' rights in mind. Devise workable policies and procedures to govern how data is processed and put processes in place that will ensure that records can be maintained accurately. In general, you have to have a data subject's consent to process their data, and in this case, a data subject being an applicant. While there are specific circumstances where consent is not strictly necessary, these generally revolve around legal requirements such as compliance with another law or to protect the data subject's rights, etc. The conditions for consent are outlined here on this slide. Consent must be given freely, specific, informed and unambiguous. Consent is presumed not to be freely given if it does not allow separate consent to be given to different personnel data processing operations. The controller must be able to demonstrate that data subject has consented to processing. Data subjects have the right to withdraw consent at any time. So when we say consent covers all processing activities carried out for the same purposes, if processing for multiple purposes, consent should be given for each of them. Companies should consider how they record consent for each purpose, what systems they have in place to manage opt-in and opt-out across channels or processes. This can be related to recruitment when you have candidates applying for more than one vacancy. They must give consent for consideration for each and every vacancy that they apply for. Individuals should be able to withdraw consent easily as it has been given, i.e. if consent was given by a tick box on a landing page, then it should be removed by a similar means. Updating preferences on landing pages or if given via SMS should also be able to be removed by SMS. Specific rules apply to children. To verify age, you must seek parental consent. This can be found in detail in Article 7. Specific rules apply to processing restricted data, which can be found in Article 9. Consent should not be considered freely given if data subject has no genuine or free choice. It is important to note that pre-tick boxes on forms does not constitute consent. the data subject must manually click the button for consent to be valid. And you may have already noticed this perhaps on a lot of marketing forms that you may be filling out online. A lot of the time forms would have been pre-ticked and you had to untick them to basically remove consent. Now it is important that these remain unticked and you have to tick them to confirm consent. So documentation of content is absolutely crucial. Privacy notes are an important and necessary way of being transparent and telling data subjects what you are doing with this information. So in particular, when you're using an online application form, having a privacy statement at the beginning that applicants read and then confirm that they have read is vital. You should have a clear privacy notice and make people aware of it on your careers website and on other recruitment marketing campaigns such as landing pages. And it should tell people what information is being collected, who is collecting it, how it is collected, why it is collected, and how it will be used. It must also say who it will be shared with, and importantly, if you're using a third-party solution such as an applicant tracking system as Landed, it must inform the candidates that a third party has access and what this party has access to. More information on privacy notices and transparency can be found on the ICO website. If you want, you can take a quick screen grab. I'll leave this website up here for you for a minute or two so you can take down the details. But the ico.org.uk provides a lot of information about privacy notes, what should be done, where it should be done, and how it should be implemented. Cookies applies to any applicant tracking system that is based on the internet. So sites will need an always available opt-out. Even after getting valid consent, there must be a route for people to change their mind, and it must be made as simple as it was given. If accepting cookies is easy as clicking a link on the landing page, then withdrawal of consent must be just as simple. Once fair notice is given, continuing to browse can, in most circumstances, be valid consent via an affirmative action. The GDPR does not specifically change the legislation around cookies, but reinforces the current e-privacy legislation, and it's important to have a clear cookie policy and monitor opt-outs or do not track requests. This means granular levels of control with separate consents for tracking and analytic cookies, for example. Many businesses are now updating their cookie policies and acceptance processes to ensure that they are fully compliant with legislation. For example, here we have EasyJet, who will now not allow a new visitor onto their site without first accepting their cookie policy. Other companies have similar notices which require positive affirmation to proceed. So in the past, you would have seen cookie policies that would have sat at the top end of your bar, but you could still go in and access the information that you were looking to retrieve or to make an application or to submit or buy a ticket. Now more companies are going to have to follow the guidelines. In fact, everybody should be following the guidelines as set here by EasyJet, where basically your screen greys out and you're not able to proceed unless you've confirmed that you accept their cookie policy. Breach and reporting of sanctions. This is the one area that everybody obviously wishes to evolve or to avoid. Data breaches must be reported with the ICO within 72 hours. In a world of increasing cyber attacks, it is inevitable that breaches will happen. The mere fact that a breach has occurred does not necessarily mean that a company will be punished. The ICO will look at how the company has handled the breach in the first instance. So as I said, data breaches must be reported to the ICO within 72 hours. Where adequate, processes need to be put in place to reduce the risk of infringement of data of subject rights, e.g. was the data encrypted or pseudonymized. Where there's a risk identified, have individuals been informed of the breach? And you may recall a few weeks ago there was something similar that happened with one of the major IT companies, and indeed with not so recently with Apple having to put out a notice to say that their individual data may be at risk. So it was implying that people had to obviously update their software to ensure that their information would be safe. So it's putting more onus on companies that, yes, breaches happen in technology, it probably can't be avoided, but it's how the companies handle that and ensure that they try to secure the data as quickly as possible. Penalties for failure to comply with GDPR are extremely punitive, however, and companies should be aware of them. Article 83 of GDPR states that fines will be effective, proportionate and dissuasive and can be imposed in addition to or instead of corrective powers of the ICO. These correct powers include things such as warnings, reprimands and ordering companies to comply with data subject requests. As a small company, you do not want to be one of the first companies to be reprimanded in the ICO. Will likely look to make an example of early offenders. So it is important to take the necessary steps now to ensure that you have adequate controls and processes in place to ensure compliance. The clock is ticking. This slide's, we've been doing this for a little while now. Less than a year until regulation comes into force. It's actually now, less than 5 months? 3 months or 4 months until regulation comes into force. So really we are up against it. Companies need to act now, if they haven't done so already, to ensure that they are prepared for this new regulation. You should be taking steps to identify what data you currently hold, whether you have lawful basis for processing this data, and whether your systems are adequate for ensuring that data is maintained in a compliant manner. In relation to recruitment, conduct an internal audit on how you collect and collate applicant information. How is this information stored and how long is it stored for? Everyday simple processes such as emailing an applicant CV to another hiring manager within the organisation or another colleague, how many copies have been printed and what happens to the printed CVs after interviews, what happens to interview notes on the applicants. All of this information is considered personal data. So it's really imperative that CVs aren't left lying around desks and that CVs aren't left on open emails and that they're not shared on personal emails. So it's really imperative to start looking at ways of how you share applicant information across your organisation. It's also important how recruitment agencies share information with you as well. So it's implicit that you act with your recruitment partners to find out how they are addressing GDPR and ensuring that they too remain compliant. Data protection is designed to essentially ensure you are prepared. This means looking at what systems are in place to handle data. How can these be modified to ensure you have a full picture of interactions with the data subject? Do you have a single view of all touch points? As mentioned previously, you must be able to prove you have put measures in place to ensure the rights of data subjects are protected. Consent cannot be relied upon, however, you must ensure that data subjects have freely given consent and have measures to place for removal of specific consent. Transparency is also a key element of GDPR, so you should update your privacy notes, cookies policies and ensure they are all clear and concise and accurately reflect how data is collected. Take steps to ensure that all data processing from a recruitment marketing perspective is open and transparent. This new regulation can be an opportunity for businesses. Consumers are more and more aware of the rights and will look to interact with businesses that take proactive approach to protecting their data. The fines for failure to comply are significant, so you really should act now to ensure that all risks are mitigated. Legislation is coming in regardless of Brexit, as I said, and will be a massive burden on businesses. The report out recently by an IT governance showed that 68% of organisations have not yet updated their processes to comply with GDPR. And that information was taken about 4 or 5 months ago, so I'm sure there are still a large number of organisations that still haven't quite got there. We are already well over we're already very close to the deadline. The notice was given almost 2 years ago, and framework for implementation is a lot of businesses are behind the curve and they need to seriously consider stepping up to ensure that they get compliant. Like I said, there are 4 months to go. Landed can help. We can bring all of your recruitment marketing and applicant trackings into one centralised touchpoint dashboard. Over the next 3 or 4 slides, I'm just going to give you a very brief outline of how we are helping companies bring their recruitment marketing process and applicant tracking in line with GDPR. It's become a major issue for us. By bringing all your organisation's recruitment marketing and applicant tracking and screening activities onto one single dashboard, you will have a central repository of data subjects information, which will make it much easier for you to maintain accurate and up-to-date information. So if you're running email campaigns, job board adverts, social media campaigns, pay-per-click adverts, all of the data coming back from those campaigns can be collated in one place. It will also be much easier to respond to the applicant subject in regards to access requests and to remove data from your systems when no longer appropriate or lawful to retain. These are key elements of GDPR. If you're working on multiple systems such as email provider, a CRM, social media management platforms, applicant tracking systems, and screening systems, you will find it difficult to accurately maintain all databases and remove data easily, and you will also struggle to get a single customer view which tracks all touch points. The landed platform ensures you obtain permission from every applicant who engages with your job advert. It includes privacy policies, cookie pop-ups and terms and conditions. But having set standard templates, and by having set standard templates in regards to your emails that you send to candidates, you can be sure that all your recruitment marketing campaigns and transparency are transparent and notices are in place. And when data subjects interact with your marketing campaigns in reference to your recruitment, you can tie all this back to the policy that was in place at the time, ensuring you have a full audit trail of consent. With a single applicant view, you can track every interaction with the data subject across all campaigns. You can also monitor the consent status of each individual, covering SMS consent, email consent, mail consent, telephone consent, consent for receiving cookies, and consent in respect of profiling and pulling candidate details. In addition, you can tie each element of consent back to the time of collection and the campaign used and the policies in place at that time. Our landed recruiters are a team of recruitment professionals, and they are on hand on demand to assist with all aspects of campaign setup and management. And this can include guidance and assistance to build digital recruitment campaigns and review results or help create your overall recruitment marketing strategy. We can also provide ongoing advice ensuring compliance with GDPR. We are taking GDPR extremely seriously, and as an organisation, we are actively training all our staff in this area so we can assist our clients with maintaining compliance. From $4.99 a month, we can provide you with the complete software suite of tools to manage your entire recruitment marketing activities, applicant tracking, and online screening. A dedicated support per month to ensure your campaigns are both effective and compliant, and most importantly, to ensure that you get the best hire from your company. Because aside from all regulations and making sure you're compliant, the main goal of recruitment has to be getting the right hires. In addition to this, we're offering a 30-day money-back guarantee, so you can try the system for a month, and at the end of that period, if you do not wish to continue, we'll offer a full refund. We do this because we're confident that once a client comes on board, they will see the value of the platform and the services we offer very quickly. We are happy to offer demos to show you how Landed can help you become compliant with GDPR, and to go into a bit more details. It's quite a complex platform and does require about a good 45 minutes to even get into the basics of it. So I'm not going to bore you with the details of that today. Hopefully I've been able to answer some of your questions. I'm going to unmic you so that if you do have any questions, you can obviously put them out there now, and hopefully we'll be able to address them. Has anyone got any questions? No? Okay, my email details are available. You can email me at either emma@wearelanded.com or info@weare. You can call me on the number below if you want to ask me anything offline on a more one-to-one basis. And I say, if you're interested in having a look at how our solution can help you ensure that you are GDP compliant, I'd be more than happy to set you up with a demo of the solution. Thank you so much for your time today. Hopefully it has put you on the right path to ensuring that you are that a bit more compliant. And please follow us online, and feel free to reach out and ask anything that you need to ask us. Again, thank you for your time, and have an enjoyable rest of the day. Right.